State. We'll be talking about visas for fiancés and spouses. I'm so happy that we got so many questions. We're going to try to answer the most popular questions first. Also, we can't really answer any questions about personal cases. We would ask you to refer those cases to the National Visa Center or our colleagues at the embassy or consulate where you applied, because we can't answer those here due to privacy concerns. So I'm just going to introduce our three participants, and then we'll get into answering some of your questions. So we're joined by Ellie. Ellie is currently a student in Iowa, but she has some very personal experience with this topic. She's a newlywed. We're also joined by Albert Sia. He's my colleague in the visa office, and he's an expert in K visas, which are visas for people that are not yet married but plan to marry once they get into the United States. And finally, we're joined by Amanda Shipley. She is a London-based attorney who's licensed to practice in New York City. She's an immigration attorney who's helped a lot of couples navigate this process. So I want to start by asking Ellie, since you have the most personal experience with today's topics, can you tell us a little bit about how you met your husband and the process that you guys undertook to get him to Iowa with you today?
Absolutely. So I was just married a little bit over a year ago, and the process with the visa took about 10 months, but before that we met in 2010. We met through an organization that conducts sport camps, so I was playing volleyball and my husband was a soccer player at the time, and that's where we met, and we just kind of stayed in contact long distance, dated for a couple of years, and then decided that we were interested in getting married, so then we began the process of actually going through immigration and getting him to the United States.
Excellent. Thank you for sharing. Albert, we just heard Ellie say that it took about 10 months to complete the immigration process, and we hear a lot from our fans on Facebook and our followers on Twitter that this process takes a really long time. So can you take us through the process a little bit and tell us why it takes so long, and then maybe what some of the average processing times are for different steps along the way?
Sure, no problem. We understand that it's frustrating to be separated from your spouse, your fiancé, for any amount of time, be it a week or 10 months, as was the case for Ellie. The process begins with you filing a petition with USCIS. You would file either the form I-130 for the spouse, or you can file the form I-129F for the fiancé. USCIS will process it, and it takes several months, probably 5 to 6 months. I would refer you to their webpage for their current wait times and their target times, and then it is sent to the National Visa Center for our initial intake and processing. The department's goal is to process these visas within 30 days of arrival from USCIS, and we strive really hard to meet that goal. Currently, the National Visa Center is averaging around 20 days for fiancé visas, and then it's sent to the post, the U.S. Embassy or consulate, where the visa application will be processed. Now, once it gets to the consular section, there are many factors that come in to play when determining how long it will take to get processed there. You have to look at the visa demand that's going on at that point. You have to see the embassy resources, the local situation in the country. Is it Carnival and everything's closed down? Are there a lot of holidays? The security situation. And you also have to see how well prepared the applicants come. And since there are so many moving parts in this process that are outside of the control of the applicant, being prepared for the interview, that's the part where you control. So we strongly recommend that you look at the USCIS webpage to make sure that the information you're submitting with the initial petition is accurate and sufficient. We recommend that you go to travel.state.gov and look at their wonderful interactive webpage that walks through, leads the applicant through the entire visa process and explains what documents need to be presented and when, what fees are required, the validity of certain documents. So if you come very prepared to the interview, that really helps you in limiting the processing time.
Thank you, Albert. And Amanda. Albert is an expert in K visas, and it sounds like Ellie also got a K visa. Can you tell us about some of the other visa categories that couples can apply for, whether they're married or not yet married?
Sure. I mean, so the other option that a lot of married couples pursue, well, they'd have to be married to pursue, would be sort of what's generally known as the green card process. But that's really the I-130 that Albert referred to earlier. And that's a petition that gets filed, and then also if one of the parties is outside the U.S. and one is within, it goes to the National Visa Center. Now, because I'm based in London, we're really fortunate here that we have a local USCIS office at the U.S. Embassy in London. And so many of our clients are able to file directly at the embassy. And this 5-month processing period that you see online for I-130s is actually 1 month at the U.S. Embassy in London. And then for other couples where both parties reside abroad, and that's what that process is available to for people in London, you can sometimes apply based on exceptional circumstances at posts around the world, and even if there's not a local USCIS office, the Department of State can process the I-130, so that helps people get to the U.S. a lot faster.
Thank you.
But those tend to be the categories. And then the other thing would be is if the spouse has another non-immigrant option to be in the U.S., if they have a separate job sponsorship or something of that nature.
Yes, we often get questions from couples who are dating and want to spend a little more time together, but they're not ready to get engaged and they're not yet married. What do you typically advise couples like that?
Well, I mean, I think people have to be careful. You see some people who definitely are going to the U.S. to try to get married right away and adjust status, which may contravene the nature of their visa. And we always, if we have a consultation to that effect, we will see if it passes the smell test to us. And, if it doesn't, there's no way an officer is going to believe it either. So what we say to people is, if they have a job offer in the U.S. and they're that's the purpose of their visit, then by all means they're allowed to go and work in the U.S. and get to know that person better. They're also allowed to go travel to the U.S. and get to know that person better. The one thing that is absolutely prohibited is misrepresenting the purpose of their visit. So if somebody's traveling on the visa waiver program, which most people know as ESTA, and you're going to the U.S. to get married and adjust status, apply for the green card right away, you're misrepresenting yourself to the officer in a lot of situations when you're entering the U.S. And those are the situations that we would say, you're absolutely not allowed to do that.
Yeah, we definitely wouldn't want people to do that because that makes it more difficult for them to visit the U.S. in the future. Mm-hmm. So I wanted to follow up and ask Ellie if you can tell us a little bit about your husband Steve's interview at the consulate with the consular officer or the embassy where he applied. And were you surprised by anything that he was asked, or what was that process like?
Sure. So after I had filed my petition, the U.S. Embassy in Belgium, where my husband is from, sent him a packet of paperwork that he needed to collect. And after he had collected that, he needed to contact to set up an appointment with the embassy for his interview. So he had gotten all his papers, went to the embassy for his interview. Papers all checked out. He was asked personal questions about our relationship, so how we met, how long we'd been dating, things like that, but absolutely nothing inappropriate or too personal. So, yeah.
Okay, thank you. And Albert, from your perspective, can you tell us why consular officers ask those kinds of questions that might seem a little intimate or personal during the interview process?
Sure. The consular officers have a lot of responsibilities at the time of interview, and there are some legal requirements. The International Marriage Brokers Regulatory Act requires consular officers to ascertain whether an international marriage broker was used to facilitate the relationship. Because of the Violence Against Women's Act, we also have to make sure that the applicant is aware of any criminal convictions for specified crimes, something that might be very personal and private to the U.S. citizen petitioner, but it's part of our legal requirements. And then ultimately, the consular officer has to determine that this is a valid relationship, that it is not a relationship that was entered solely to facilitate immigration to the United States. So we have to make sure that there is a true spouse or fiancé relationship, and we have to make sure that they are able to get married within 90 days of arrival into the United States. So sometimes those questions do seem bit personal and touch on private issues, but it's part of the due diligence that consular officers must do.
So, Albert, are you saying that it's possible for a couple to be in a completely valid relationship for purposes of immigration, even if they've never met?
Well, one of the fiancé requirements for the petition, the form I-129F, is that the petitioner, the U.S. citizen, and the beneficiary, the foreign fiancé, must have met within 2 years of filing the petition. Mm-hmm. There are some exceptions that USCIS would review that wouldn't be part of our purview at the visa adjudication stage, but yes, it's one of those requirements that they have to have met. Once you get into the more nuanced, let's say, marriage-based visas, like proxy marriages and stuff like that, those also have certain requirements, too, that are so nuanced I don't want to bore the audience.
Right, so it's probably best in those cases to talk to someone like Amanda. And my question for you, Amanda, is a lot of people find that this process is really complicated. Can you provide some insight as to whether people should contact an attorney, how they can navigate that process, if there's maybe a directory of attorneys who deal with this subject matter that are better than others and that are in many different countries, even if so that applicants who aren't in the U.S. can find someone to advise them on U.S. immigration-related issues?
Yeah, so I mean, it may surprise you to hear from an attorney that not everybody needs or uses an attorney for this process. You know, what I generally tell my clients is, or potential clients is, how comfortable they feel with navigating the process, with the forms, how much time they have, because it can take a long time to figure out what needs to be filed. I mean, there's great guidance from both USCIS and the Department of State, but it can still take a lot of time to figure out. I would say that people who have any kind of adverse immigration or criminal history should absolutely get an attorney. And the other thing is that mistakes are often very expensive to fix, if they can be fixed at all, and quite time-consuming. So to answer your other question, yeah, I'm a member of the American Immigration Lawyers Association. It's AILA.org is the website, and we are 13,000 members of U.S. immigration lawyers who specialize in this field. And there is a lot of bad information online. We get it from our clients frequently. That, well, I saw this or my friend did this, and so I would recommend that you reach out to somebody who practices U.S. immigration full time. The process and the law interpretation changes frequently, and you don't want to be paying money to somebody who doesn't know what they're doing, quite frankly.
Yeah, that's a good point, especially about expensive mistakes. And I would also add that from our perspective, we often see that mistakes cost even more time in the process, which is particularly burdensome. So question for Albert from Christina on Google+. She says, my husband now lives in the U.S. I was told I'm not eligible under Section 221G. How long will it take for my case to be reviewed again?
Well, that one's a little bit specific. Section 221G is a code that can signify that the consular officer is reviewing all the information, that needs more information back from the applicant. So maybe an example could be that they submitted the wrong type of birth certificate, and the applicant would be refused 221G until they brought the appropriate document. It could also be refused 221G because the consular officer had concerns about the validity of the relationship or the ability to finalize the marriage in the United States, and it was refused 221G. Without knowing why it was refused, I really can't make an opinion, but for that situation, it's very important to reach out to the U.S. Embassy or Consulate where she processed her visa application and find out, is it pending one document, is it pending some administrative processing on our end, or was it something that was sent back to USCIS for their review and ultimate determination, and she would need to contact USCIS. So it's very important to reach out and get the specific information from the consular section.
Ellie, did you have a point at any time during the process where you had to, or Steve rather, had to go find more documents to submit, or you guys were delayed?
There was actually only one point. He went to his appointment at the U.S. Embassy for his interview. One of the papers that he needed was a certificate saying that he was not involved in the military in Belgium, and he did not have that, couldn't produce that for the first interview, so they did have to have him go back to his town hall to ask for that paper. And it did turn out to be a little bit of a headache because that paper actually supposedly did not exist. But so just things like that where you have to put a little legwork into it. But eventually it was doable. So.
Yeah, so I think that's a really great example that highlights how you can be refused on the basis of 221G, or your interview can be postponed on the basis of 221G, but it's completely benign and relatively easy to fix. But it's obviously very unique to the case. So as Albert said, maybe reach out to the embassy or consulate where you applied. For Amanda, we just got a question from Twitter. I'm sorry, from the Google Plus page, from Tom. He says, I'm a U.S. citizen living outside the United States, married to a non-U.S. citizen. Can we apply to come to the United States as a same-sex couple?
Oh, absolutely. Yeah. Once DOMA was overturned, the Department of State has been at the forefront of making same-sex marriage a reality for these couples. And, you know, in fact, in the U.S. Embassy in London, they had a reception to celebrate it, and we've seen great recognition of this across the world from the Department of State. And in fact, I know that some posts where couples are in countries where same-sex marriage is either illegal or is, you know, puts the person at risk of, you know, being the victim of a crime or something like that, they're working towards providing safe havens for these people to apply for their green card, or, you know, for their immigrant visas there.
Great, thank you. So we'll ask another question for Albert. We actually had this question a few times. So several people asked about what happens if you're a U.S. citizen living abroad and you're engaged to be married, or you're into the immigrant visa process and you've had a child together. How does that work, Albert? And maybe to follow up, Amanda, could you provide some insight?
Sure. Fiancé visas have a derivative child possibility, but one thing to remember is if you are a U.S. citizen and your child is born abroad, that child could qualify for U.S. citizenship. And I would recommend you go to travel.state.gov and review the information on what is required for a first-time passport or a consular report of birth abroad. There are different requirements, whether the child was born in wedlock, out of wedlock, and if it was a U.S. citizen father or a U.S. citizen mother. But if the child can obtain, if the child cannot receive U.S. citizenship through transmission from the parent, let's say they didn't live in the United States long enough to transmit U.S. citizenship, they can come in as a derivative of a K visa or as their own standalone petition. As the there are plenty of options, and that's where your attorney, if you choose to use one, can help you out.
Yeah. So Amanda, how could that work? For example, if a couple is engaged to be married and then they visit each other and find out 9 months later that they have a child now, do they just interrupt the petition process, or how does that work?
Well, I mean, to Albert's point, I think that, yeah, the most important thing to assess initially is whether or not that child is already a U.S. citizen, because obviously a U.S. citizen can't get a U.S. visa and needs to travel to the U.S. on a U.S. passport. So I think, yeah, the State Department's website in general is very good, and also I think a lot of people are afraid to go into the embassy because they've had an experience applying for a visa, or they've heard about, you know, that it's a scary process and that, you know, they get 2 minutes in front of an officer. If you go to American Citizen Services, that's a separate part of the embassy, and, you know, make a point. Most of the embassies will schedule appointments for you, and, you know, you can go in there, have a conversation with an officer, and talk about, you know, whether or not that child has a claim to citizenship. But a lot of the information is already online, And if it's confusing, because it is based on, you know, when the child was born and how long the U.S. citizen parent lived in the U.S., as Albert already mentioned, you know, you can look at that stuff online, or of course, you know, if you need to retain an attorney, we'd be happy to help.
Okay, thank you. And another question from Eddie. He asked, I'm a 2014 DV, so diversity visa, lottery winner, now living in the United States. I met my fiance after I submitted all the documents to KCC, so the Kansas City Processing Center for Diversity, Kentucky Processing Center for Diversity Visas. And she was not included in the original documents submitted to the Kentucky Consular Center. What can I do for her to follow me to the United States? Albert?
So to qualify as a derivative for a diversity visa, you have to be the spouse or child of a U.S. citizen. Of the principal applicant, the person who was selected for the diversity visa. There is, under U.S. law, no category or preference for the fiance or partner of a winner. Now that he, I believe it was a he, is living in the United States, he can apply for his fiancée once he becomes a U.S. citizen. Only U.S. citizens can petition for their fiancés. Or since he is a lawful permanent resident, he can file a Form I-130 petition for his fiancée once they get married. So there is no fiancé option for lawful permanent residents, but yes, for spouses and children of lawful permanent residents.
Okay, thank you. So another question for Amanda now. This person has submitted a question from Google+, and Emily wants to know, my boyfriend and I are planning on getting engaged, but we were wondering if he has a better chance of getting a work permit without claiming a relationship to a U.S. citizen. Is it sometimes smarter to apply on your own? And if we get engaged, is he required to apply for a fiancé visa, or can he still apply alone?
Okay, well, I touched on this a little bit earlier, but I mean, the main thing to sort of hammer home is you always have to be truthful. So if there is a question on the non-immigrant visa application that asks whether or not you have any immediate relatives in the U.S., and immediate relatives, as described on that form, lists fiance. So, I mean, I would always advise that if it's your fiance and the question asks, you would answer yes. So, you know, it's not something that you always have to be forthcoming about, but equally you can't misrepresent that that's the case. And again, it really just depends. I mean, if he's applying for a visa type that allows for dual intent, like an H-1B or an L-1, there's absolutely no issue with having a U.S. fiance. If it's another visa category, if they're genuinely applying for that, so say he, you know, was accepted into a university program, it's where he really wants to study, it makes sense. His primary purpose in going to the U.S. is to study, not to, you know, get married or be with his fiance, then that's going to be an acceptable way to go to the U.S. as well. But again, as I said before, you know, consular officers interview people, you know, hundreds of people a day, 2 minutes at a time. If it doesn't sound legit to us as attorneys, there's no way that a consular officer is going to buy the story.
Great, thank you. So question for Albert and Amanda from Matt. My fiance and I are getting married in the Philippines where she lives. Can we file an I-130 right away, or do we need to wait a specific length of time to file?
You can file an I-130 as soon as there is a lawful marriage at the time of filing. So yes, you can file right away and just follow the instructions on uscis.gov and find out their filing instructions. If the U.S. citizen is residing in the Philippines, I would recommend to look at their local filing options there because I believe USCIS does have a presence in the Philippines. But yes, just please refer, once you're married, yes, you can file an I-130.
Okay, thank you. And we only have a couple more minutes left, so I want to give our last question to Ellie. Ellie, after Steve came to the U.S., how quickly were you able to get married, and what was the transition process like between his moving there, your getting married, and then his getting the green card?
Sure. Okay. I remember the timeline here. Steve was granted his visa in December of 2013. He decided to stay for Christmas with his family and came over directly after that. Then we got married on January 4th, so he was here for about 1 week before we got married, and I had planned our wedding in about 2 weeks, so it was all pretty hectic. But it ended up working out. Immediately after we got married, we filed for our adjustment of status. And while you do have 90 days to get married and apply for the adjustment of status, it was beneficial for us to do so right away so that he would get his work card sooner and be able to actually get his life in the United States going. So that took a while to get his work card as well, so there was that period of just waiting, not having a whole lot to do. And once he got his work card, he was able to find a job. He's now just enrolled in a community college in the area. So he's adjusted really well, but I would caution to anybody considering going through this process, it is you have to be very patient. It takes a lot of willpower on both ends, so it's doable. It's worth it if you're serious about going through with it, but it does take quite a while and quite a bit of patience.
Well, thank you. I'm so glad it did work out for you and Steve.
Yeah, me too.
2 weeks for planning a wedding is very impressive also. And that concludes our time today, but I want to thank those of you who are watching, and I want to thank Amanda, Ellie, and Albert for offering their expertise and each of their perspectives. Happy Valentine's Day to everyone, and if you have more questions about spouse or fiancé visas, please visit travel.state.gov. Thank you.